Number 1.
May it please, Your Lordship. This is a petition under Article 227 of the Constitution of India for challenging
Lok
the...
Adalat's award.
Yes, my Lord.
Yes, on what
Lok-
ground?
Yes, my Lord. I have... my Lord, let me speak out at the brief facts, my Lord, for filing this case, my Lord. So I have a landed property at Kolasip, Twichaveng. And the respondent number 1, my first cousin, he was living in my Assam type building covered by
Is
my
this a
LLC.
revision?
Civil revision petition, my
But
Lord.
is a revision maintainable?
Yes, my
Because
Lord.
I think the only remedy is a 226.
226 and 227, my Lord.
But you have filed under a civil revision.
Yes,
This is under what provision?
under 227, my Lord.
Then it has to be registered as a WPC, I think.
My Lord, maybe later I can give
Michael?
a coordinate bench of this court judgment also, my Lord, if it is required.
227 is registered as CRP here. I have a feeling. Yes, no, maintainable only on limited grounds.
Yes,
Certainly, the award of the Lok Adalat can be challenged on
Yes.
limited grounds.
Yes, on a limited ground.
Fraud, misrepresentations,
Mm.
right? That
Yes,
is why
my
I
lord.
am asking, what is the ground on which
Yes.
are you assailing the award of the Lok Adalat?
Yes, my Lord. I have made a complaint against the respondent number 1 because he did not want to vacate my building. So I requested the Lok Adalat to expel from my building. And then on 12/9/2024, he was summoned to appear on 14/9/2024. And he appeared. And then in the body of the Lok Adalat award, my Lord, if Your Lordship may please come to page number 20.
Page number?
20. Annex 5, my Lord.
Yes.
Yes, my Lord. One thing I'd like to point out is that defendant is Rin Pui, daughter of Sizai Remthanga. She is the respondent number 2, but my Lord, she was not present before the Lok Adalat.
So, Lanpui.
Rin Pui, my Lord.
Rinpui is defendant number, the respondent number 2.
2, yes, in this petition.
And you are?
She was not a
Who are
party
you?
in Lok Adalat.
Who are you?
She is my auntie, my Lord.
No, who are you?
I am the petitioner before the Lok Adalat.
You are the petitioner before the Lok Adalat.
Yes, my Lord.
You were present,
Along with the respondent number 1.
but you were present.
Yes, my Lord.
There was a compromise.
No, my Lord. There is no discussion.
There was no compromise deed.
Yes, my Lord. Because, my Lord,
Let us see the award.
yes, in
Where is the translated copy of the award?
from page 23, my Lord.
Yes, read.
From what, my Lord?
Yes, read.
The dispute between the parties having been referred for determination to Lok Adalat and the parties having compromised settled the case matter the following award is passed in terms of the settlement. In the year 2016, Mr. Joseph Vanlal Loma, son of so-and-so, resident of so-and-so, gifted half
Where
of...
is this agreement that they are mentioning here?
Yes.
That and the Lok Adalat made an agreement settlement as under? From where this has come?
From this year, my lords, next from
That's
page,
right, that's
page
right.
24,
Yes.
second para.
This year, 2024, dispute arose between the parties regarding the landed property gifted, and the Lok Adalat made an agreement. Where is this agreement?
This is not an agreement because if Your Lordship may please come to point number 5, agreement point number 5.
Yes.
The landed property shall be distributed according to the gift deed, and the lower portions shall be belong to Miss Rinpui. So, my lord, there is no discussion. On that day, on 14/9/2024, the respondent number 1 produced this gift deed. So, according to the gift deed, Adalat award was drawn, my lord.
And the dispute was regarding the gift deed.
No, my lord. So the respondent number 1 did not want to vacate my landed property, my lord.
No,
So that's
the
why.
respondent number 1 was occupying the landed property on the basis of a gift deed, right?
No, my lord, because they asked me, because they are my relative. So they did not pay, I did not demand any rent, my lord. They are living in my building without paying anything.
I can only issue notice.
Yes, my lord. My lord, at this stage, may I have only one prayer. So the respondent number 1 started constructing his building.
No, nothing.
So if the award may be stayed until
I am not staying the award right now. I am issuing notice on both interim as well as the petition. Heard, Mr.
yes, my lord, rather.
So and so, Learned Counsel for the petitioner, stop. Issue notice, returnable 3 weeks. Registered post AD within a period of 2 days from today. Heard on interim, issue notice on the interim as well. List after 3 weeks on a date to be fixed by the registrar.
Highly obliged.
For admission, item number 2.
Yes, Mr. Lalramenga.
Yes. My lord, in this matter, I
This is
have...
that review.
Yes, this is the review.
Determination. That was the ground.
Please, Milad. Milad,
Yes,
I am today
Ms.
seeking
Fanai?
Milad's,
Sorry?
Milad's a short. Milad, I am today seeking a short accommodation. I am Milad's in personal difficulty. Milad, may have it next week anytime for
All right,
argument.
Mr. Lalramenga, any objection?
Next week, Monday at least, my lord.
Monday?
Yes.
No
Ms.
problem.
Finai?
Yes, my lord, I'm for the petitioner, review petitioner.
As prayed for by Mr.
Arpit Dwivedi, Milad.
Mr. Roshan Subedi, right? No.
Arpit Dwivedi.
Sorry?
Arpit.
Arpit Dwivedi.
Item number 2.
A. Divedi, right?
That's
Mr.
right.
A. Divedi, Learned Counsel appearing for the petitioner, relist on Monday so and so.
Grateful.
Much obliged.
For orders, item 3.
Mr. Lalramenga, you please, and Mr. Ms. Finai, I think he's already closed it, but
Because I am there, I am there.
Mr. Divedi, please have those decisions of review,
Please, Milad.
Yes,
Please.
yes.
because I have serious doubts that
Please,
your
Milad.
review is maintainable.
Please,
So
Milad.
be prepared on Monday, no further adjournment is going to be given.
Please, Milad. Please. Grateful. Deeply obliged.
Yes,
My lord, I'm the petitioner, I'm the applicant for respondent number 3. However, my lord, today
who's it? Yes?
the learned AG is, PP is appearing.
Yes, Ms. Vani?
Yes, Your Lordship.
My lord,
Who is appearing?
I'm appearing
Yes.
on behalf of the state.
I'm sorry, Ms. Finai, I couldn't hear what you said. I thought you were asking for some time. Are you
Yes,
asking
my
for
lord.
some time?
Yes, my lord, because I'm having court and I have some
Okay,
difficulty.
okay. No
I'm
problem.
like-
This court is going to accommodate you. As prayed for by Ms. Finai, so and so, Learned Counsel appearing for the petitioner, which is not opposed by Ms. Vani, so and so, Learned APP for the state respondent, relist when?
My lord, can it be relisted on Thursday?
Yes, why not?
My lord, can it be listed on Friday?
Friday.
Obliged.
Friday.
Item
Yes.
number 4.
Yes. First time this has come.
My lord, for a second time.
Second
On the last
time.
occasion, the trial court records are called for. Perhaps it has come today.
Yes, Ms. Vani, are you appearing?
Yes, Your Lordship, I will be appearing.
The records have come. This is a bail,
Yes, my lord.
21
C.
C.
Redwood 29, in the case of my client, my lord.
You are ready for arguments?
Yes, Your Lordship.
Okay. Yes, please.
May it please, my lords. My lords, this is a bail application for my client who has been languishing in jail since 2 years, 1 month, 4 days, my lord, as on today.
How
And,
many years?
2 years, 1 month, 4 days.
2 years,
1 month, 4 days.
1 month,
4 days.
4 days.
He was arrested on 11/6/23.
Which was that case of the apex court?
My lord, there are, I have.
Is
a
it
few
Ravi
judgments.
Prakash?
My lord, there are quite a few recent judgments that I have. One is Ramlal versus State of Rajasthan. Another is Mahindra versus State of Rajasthan.
I think that Ramnath. I think what
Yes.
was the year there?
This is 17/9/2024, my lord. So in both of these judgments, my lord, the prolonged period of incarceration was taken into account, along with the fact that there was no prior criminal antecedents of the accused. Those were the sufficient grounds for enlarging on bail. And apart from that, my lord, the section 47-48 notices were not served. And the arrest memo also does not disclose any grounds on why I was arrested.
Where is the arrest memo?
My lord, will you please to...
You are also relying on Vihan Kumar.
Yes, my lord, of course. Prabir Purakashya Vihan Kumar.
So where is your arrest memo?
My lord, my arrest memo is at page number 23.
Yes.
If I may kindly read, my lord.
Yes.
I, SI so-and-so of Excise and Narcotics Department, hereby seize
One
the...
second. Ms. Vani, in the meantime, can you please see the records whether the arrest memo or there is anything to indicate that at the time of arrest, the grounds of arrest was disclosed? You please see, because if that is so, then that is the only ground on which this court will have no choice but to enlarge the petitioner on bail. So please see that.
May I continue, my lord?
Yes.
I, SI so-and-so of Excise and Narcotics Department, hereby seized the undermentioned contraband articles and
Mr.
vehicles-
Deka, right?
My lord, Borua.
Barwa,
Orinder
sorry.
Borua.
Orindam Barwa. Mr. Barwa, 23 of which page?
Annexure 2 column, my lord. Page number 23. It's a handwritten
It's a handwritten.
page. Yes,
Okay,
my
okay,
lord.
okay. Yes, I got it. Yes.
May I read, my lord?
Yes, please.
I, SI so-and-so of Excise and Narcotics Department, hereby seize the undermentioned contraband articles and vehicle on 11 June 2023 at 12:05 a.m. from the special chamber of the seized vehicle at so-and-so East, so-and-so petrol pump in the presence of below noted reliable independent witnesses. I also arrested the joint possessor mentioned below on the same date, time and place. Then number 1 is my client, my lord. He was the driver of the vehicle.
But nothing is mentioned.
Nothing, my lord, nothing.
So this is the arrest memo.
Seizure and arrest memo, my lord, 2 in 1.
Any inspection memo?
No, my lord, not that I am aware of. And my lord, as my lords can kindly see down below.
And when were you arrested?
My lord, I was arrested on the same date. The date is below, my lord, 11/6/23.
11/6/2023. And the FIR is dated?
FIR is on the next date, my lord, page number 25.
Dated?
I apologize, my lord, on the same date, 11/6/23.
11/6/23. Yes. And trial has started.
Yes, my lord, trial has started and till date 4 PWs have been examined.
Out of?
14.
Out of?
14.
Out of 14, 4.
Yes.
Yes. It appears that ground of arrest not disclosed.
Yes, Your Lordship.
If that is so, that is the only ground.
Yes. However, my lord, as per the arrest, they have given the intimation.
What
They had-
intimation?
They had arrest intimation. They had informed him.
Is that sufficient for complying with the constitutional guarantees given to the arrestee?
Yes, Your Lordship, as per the judgment which you have cited in Vihan Kumar, Your Lordship, the main thing which the court wanted to know is that whether arrest intimation was given to the accused.
Not arrest intimation.
Grounds of arrest.
Ground.
Yes. So in order
He must
that
be
the
fully
accused-
aware for what reason he has been arrested.
Yes, Your Lordship.
But where is that ground? What is it given? Please read.
arrest was made in the light of interrogation of accused.
No, but read 23. This is the arrest memo. Where are you reading from?
No, I have looking in the DCR.
What are you reading from?
This is page 23.
Yes, read. Do hereby seized the undermentioned contraband articles and vehicles on so and so from the special chamber of the seized vehicle at so and so. Then petrol pump in presence of the below noted so and so independent witnesses. I also arrested the. I can't
I
read.
also arrested
The joint
also in
possessor.
The joint possessor
mentioned
mentioned
below,
below
on, the
on so and so.
same
That's
date and
it.
time. Yes,
That's it.
that's it.
That's not sufficient. That's not sufficient.
But he has given his signature. Your
So
Lordship.
what?
My lord, it's a
And
thumb
so what?
imprint.
And moreover, my lord, he is aware on what ground he has been
Ms.
arrested.
Vani, you read Vihan Kumar. We'll take it up tomorrow.
My
You
lord.
read Vihan Kumar. Because I think after reading Vihan Kumar, you will concede that it has not been given. You are ultimately an officer of the court. Your duty is not to support unnecessarily keeping someone in the custody without following the law. Your duty is to ensure that justice is properly rendered, isn't it? So
Yes,
you
sir.
read Vihan Kumar and make your submission tomorrow. You're from Guwahati?
My lord, I'm
So-
flying tomorrow morning, in fact. May
We'll
this
take it
matter
up at 10:30. We have a division bench tomorrow. Okay. We'll take it up at 10:30. You have your.
My lord, if I may make a suggestion, I have a copy of Vihan Kumar. If I can pass it over and this matter will be taken up as the last item, perhaps that would be sufficient.
At 2
time.
o'clock?
Yes, Your Lordship.
At 2 o'clock?
I'll provide a copy, my lord.
Give her.
Yes, I'm obliged.
You read Vihan Kumar. And there are 2-3 judgments that I have given. So I'll give you a copy. You read that also.
So obliged, my lord.
OP. Please give Vani the other case. Do you ask Bidika for that reported case? How do you? Ask Bidika for that article 20.
Item 5.
I would like to seek
Notice first time.
that is true, Your Lordship,
Yes.
but I would have to, I'm afraid I have to seek Your Lordship's indulgence with the permission to withdraw the IA
You want to withdraw?
with liberty to file afresh.
Okay, as prayed for by Mr. Lalfa Kwama, learned counsel, appearing for the appellant, the interlocutory application stands withdrawn with liberty to file fresh.
My Lord. Deeply obliged.
Disposed of, huh? Yes.
Hearing list, item numbers 1 and 2.
This 1 and 2, Your Lordship, we are awaiting the outcome of a connected case in the Supreme Court, and that has been reflected in the previous judgment as well, orders as well. I think we may need some time. We're still waiting for that. It's regarding customary law.
Which is the last order? Mr. Lalfa Kwama, learned counsel, appearing for the petitioner, along with
I'm appearing on behalf of Mr. A.R. Malhotra.
MS, your
Khalil
name?
Samwani.
So and so, learned counsel, appearing for the respondent, submits that the matter is sub judice before the apex court and accordingly seeks accommodation in the matter. In view of the aforesaid submission, the matter stands adjourned sine die. Parties are at liberty to approach the registry as and when there is any development before the apex court.
Deeply obliged.
Item 5.
This is 1, 2 and what about 3? All right, fine.
My lord, if this matter may be listed after a week.
You are for?
I'm for the petitioner. Item 5.
Item 5. As prayed for on behalf of Mr. A.R. Malhotra, learned counsel for the applicant, relist when?
After a week, my lord.
After a week.
Yes, my lord.
Relist after a week on a date to be fixed by the registry.
Item 6.
Item 6, my lord, state is the applicant.
Yes, so do you want to do it today?
My lord, the counsel, respondent counsel, I have not seen in.
So we'll keep it
Please,
in the
so-
list.
Yes, your lordship, let it be in the list.
7.
7, I have not seen the counsel also. my
All
lord.
right, we'll keep it in the list. 8. Mr. Lalremenga.
This may kindly be passed over for today.
All right.
Linda is-
You want it to be called on any particular date or otherwise?
Yes, it may be.
It will be there in the list. This
Yes,
list
madam.
is valid for this week.
Yes.
This week, no?
Within this week, yes, ma'am.
In case you want a particular date, you both can decide and you can let Mr. Michael know.
All right, madam.
All right? Yes. Next. No. What about 9? Anybody there for 9?
Again, Mr. Malhotra, my lord.
Yes. Do you want it to do
If
today
this
or any
matter
other day?
May also be kindly listed after a week.
After a week. Why
ma'am.
after a week? Why not any of this day? I am here for this whole week. What will I do? Okay, we are keeping it in the list. Yes. 10. All right, let it be in the list. Done, na? 11, is anyone? 11, are you ready?
I am the amicus, so it may be in the list so that we will make an attempt within this week, my lord. Mrs. Vani is appearing on
All
the
right,
other side.
Ms. Vani, choose a date and just tell
Yes.
him within this week. He'll call it up on that day.
Yes.
Thursday, if possible. Then.
My lord.
Thursday.
All right.
Yes.
But you let him know today, because the court also prepares and come then.
Yes,
Right?
yes.
Okay.
We'll do it, my lord.
AC is fixed. AC is fixed. Huh? I don't know. It was feeling. I thought it was fixed because it's cold. No problem. Yes, Miss Dani.
Yes, Your Lordship. I have gone through the
See,
judgment.
because the moment there is an argument from the other side that the grounds of arrest as contemplated under Article 22(1) of the Constitution of India has not been met with, the burden shifts to the investigating agency
Exactly.
to show that the grounds of arrest has been informed.
Yes,
So
Your
please
Lordship.
show me if it has been informed. And
Yes.
if it is not informed, then be fair to the court. That's all is what is needed right now.
Yes, Your
Because
Lordship.
this issue is well settled. That is all that you need to show. If the record shows that it has been informed, end of the matter.
Yes, Your Lordship, in the arrest memo, there is the arrest memo, and it has been written everything there.
What is written? Where is the
arrest
brief
memo.
facts constituting the arrest? Where are those? Page 23 is the arrest memo.
Not that one, Your Lordship.
Then
In the trial court report. Page
yes.
Here, Your Lordship, it is written that the amount which they have seized, and even the ignition keys were seized. So he is aware on what grounds he is arrested.
Yes, Mr. Barua, what do you have to say?
My lord, I was not furnished with this copy. I only have this seizure and arrest memo.
This is the arrest memo, the original arrest memo.
Yes, original
My
arrest
lord,
memo.
is this pertaining to Nazimul Hussain Borbhia? Is
Yes,
this pertaining
it
to
is
Nazimul
pertinent-
Hussain Borbhia?
pertinent.
Have a look. Mr. Barua, have a look.
No, my lord, this arrest is not my arrest memo. This is regarding two other people called Kutbul Alam Loskor and Sukurali Mozumdar.
All right.
This is not
Ms.
mine.
Vani, please point out the arrest memo leading to the particular petitioner. Because page 23 itself is the arrest memo.
That is my arrest memo. This is my arrest memo.
Even here, Your Lordship, it is written that it was seized from the special chamber of the seized vehicle
So?
drove by him.
So
He is,
what happens if it
he-
is seized?
he is aware on what
How does
ground
he, what is he aware that something has been seized from his chamber? How does that satisfy Vihan Kumar?
Yes, Your Lordship. In Rehan Kumar, it is written that there is no requirement of communicating the grounds of
There is no
arrest in
requirement
writing.
of? There is
There
no
is-
requirement of?
Communicating the grounds of arrest in writing.
Is it?
Yes,
Let us see Vihan Kumar.
it's in para 13.
No, let us see para 21. The conclusion. Yes, one of you please read the conclusion of Vihan Kumar.
My lord.
Mr. Barwa,
Yes, my
read
lord.
it for all of us.
Yes. Therefore, we conclude, number A, the requirement of informing a person arrested of grounds of arrest is a mandatory requirement of Article 22, Clause 1. B, the information of the ground of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language in which he understands. The mode and method of communication must be such that the object of the constitutional safeguard is achieved. C, when arrested accused alleges non-compliance with the requirements of Article 22, Clause 1, the burden will always be on the investigating officer / agency to prove compliance with the requirements of Article 22, Clause 1. D, non-compliance of Article 22, Clause 1 will be a violation of the fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to personal liberty guaranteed by Article 21 of the Constitution. Therefore, non-compliance with the requirements of Article 22, Clause 1 vitiates the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet and trial, but at the same time, filing of charge sheet will not validate a breach of constitutional mandate under Article 22, Clause 1. E, when an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22, Clause 1 and other mandatory safeguards has been made. And F, when a violation of Article 22, Clause 1 is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail even if statutory restrictions on the grant of bail exist. The statutory restrictions do not affect the power of this court to grant bail when the violation of Articles 21 and 22 of the Constitution is established.
Read 23 now, page 23.
Para 23, my lord.
Page 23 of the brief.
I, SI so-and-so of Excise and Narcotics Department, hereby seized the under-mentioned contraband articles and vehicles on 11th of June 2023 at 12:05 am from the special chambers of the seized vehicle at so-and-so petrol pump in presence of the below noted relatable independent witnesses. I also arrested the joint possessor mentioned below on the same date, time and place. Then the accused name is...
Number
stated.
1 is the petitioner?
Yes, my lord.
That's all, isn't it?
That's all, my lord.
All right. This is the FIR is 11/6/2023.
Yes, my lord.
Now, Bansal came when?
My lord, Bansal...
I have it.
Bansal came in 2024, my lord. I don't
3/10/2023.
Yes.
So, Bansal is after 11/6, right?
Yes.
Okay. Only Vehan Kumar then.
Yes, ma'am.
Yes, please take down. Heard Mr. A. Barwal, learned counsel appearing for the petitioner. Stop. Also heard MS Vani so-and-so, learned APP for the state respondent. By way of this application under section 483 of the BNSS 2023, the petitioner I. Muhammad Nazimul Hussain Barbhuya, alias Nazimul Hussain Barbhuya, is seeking grant of bail in connection with Sessions Registration Case number 278/2023 under section 21C of the NDPS Act 1985, pending before the Learned Judge Special Court ND and PS Act Aizawl, Mizoram. The brief facts of the case is that counsels, you may take your seat, please.
I'm obliged, my lord.
that an information was received by the Sub-Inspector of Excise and Narcotics, Anti-Narcotics Squad Aizawl, Mizoram on 10/6/2023 to the effect that a bulky transportation of heroin was being carried by one Katbul Alam Lokar in an Ashok Leyland truck from Champai to Aizawl. Accordingly, the vehicle was intercepted at Champai Road on 10/6/2023. Stop. Thereafter, on 11/6/2023, the petitioner along with one Abdul Kalam Lokar was also arrested and some was arrested and some suspected heroin weighing 5810 kgs were seized along with an Ashok Leyland truck bearing registration number AS 11EC 5636. Stop. Accordingly, a seizure cum arrest memo was prepared. Stop. Thereafter, the Sub-Inspector of Excise and Narcotics, Anti-Narcotics Squad, Aizawl, Mizoram, submitted a report of seizure and arrest on 11/6/2023 to the Officer in Charge, Anti-Narcotics Squad, Excise and Narcotics, Aizawl, Mizoram. Accordingly, a case being EXN 162/2023 dated 11/6/2023 under section 21C of NDPS Act was registered. Upon completion of 48 hours of investigation in excise custody, the Sub-Inspector of Excise and Narcotics, Anti-Narcotics Squad, Aizawl, Mizoram, by application dated 14/6/2023, sought remand of the petitioner to judicial custody till the completion of the investigation of the case. Accordingly, the prayer was allowed and the petitioner is languishing in jail since 14/6/2023.
My lord, there is a forwarding report prior to that dated 11/6/23.
Then say since 11/6/2023. That should, I think that will take care, Mr. Barwa. Upon the investigation being completed, the investigating officer found the petitioner prima facie guilty of abetting the offence of drug trafficking under section 29, read with section 21C of the NDPS Act 1985, and impleaded him in the complaint sheet submitted before the Learned Judge Special Court, ND and PS Act, Aizawl, Mizoram, on 22/7/2023. Stop. Thereafter, a session registration case number 278 of 2023 was registered and the trial has commenced. before the learned special judge, Special Court, NDNPS Act, Aizawl, Mizoram, hereinafter referred to as the trial court. Since the petitioner earlier at the investigation stage was High Court, first time you have come, na?
Yes, my lord.
Don't mention anything. Accordingly, the present bail application has been filed. Stop. Mr. So-and-so Barwal, learned counsel for the petitioner, submits that despite in the report submitted by the Sub-Inspector of Excise and Narcotics Anti-Narcotics Squad, Aizawl, Mizoram, on 11/6/2023, no imputation was made against the petitioner, who was merely the driver of the vehicle, and it was clearly stated that one Katbul Alam Lokor, who was subsequently arrested on the same night at 2:15 am, was the rightful possessor of the suspected heroin, and one Abdul Kalam Lokor, who was arrested took out the suspected heroin from the concealment of the seized vehicle, the petitioner has been wrongly framed in the case, wrongly implicated in the case. He further submits that the grounds of arrest as contemplated under Article 22(1) of the Constitution of India has not been informed to the petitioner, which vitiates the arrest, and as such the petitioner is liable to be released forthwith. In support of the aforesaid submission, he relies upon the following decisions of the Apex Court.
My lord, page number 14 of the petition. Page number 14.
I am giving.
Page number 14 of the petition I've
You
mentioned.
have
the
it here?
citation. Yes, you mentioned the citation.
Yes.
Page number 14, ground E, my lord.
E.
Yes. Down below, Vihan Kumar is in bold.
The citation is there.
Yes, my lord.
Okay. Bihan Kumar versus State of Haryana and others, reported in 2025 SSC Online, Supreme Court 269. number 1. Number 2, Prabir Purkasta versus State and City of Delhi, 2024, 8 SSC 254. Stop. He further submits that out of 14 witnesses, only
4, my lord.
4 witnesses have been examined till date, and because of the snail speed pace of the trial, the petitioner has been languishing in jail since last 2 years, 1 month, 4 days. And therefore, his right under Article 21 of the Constitution of India is totally infringed. And on that ground alone, he is liable to be released forthwith without, despite of the statutory restrictions as contained under the provisions of Section 21 and Section 37 of the NDPS Act. Stop. In support of the aforesaid submission, he relies upon the decision of the Apex Court in the case of Ravi Prakash versus State of Odisha, reported in 2023 SSC Online Supreme Court 1109. Any more?
My lord, Ramlal versus...
Citation, where is the citation?
my lord, it's in page number 13, my lord, ground number C.
Ground number C.
Yes, my lord.
Yes.
In bold.
Mahendra versus that one.
Yes, the second one, my lord. Ramlal versus State of Rajasthan.
Ramlal versus the State of Rajasthan, reported in 2024 Supreme SC at page 835.
And also Mahendra, my lord. I rely on both.
Next, Mahendra versus the State of Rajasthan, 2024 Supreme Online Supreme Court 12367. MD Taziur Rahman LS Taziur Rahman versus State of West Bengal, 2024 Supreme Online SC 11722. Pranab, you will get the citation at page 14. That's all, isn't it?
My lord. Well, a slight correction, my lord, regarding the quantity. It is 5.180. Point has to be.
Got it, na, Pranab? Per contra, MS Vani so and so, learned APP submits that it is clearly mentioned in the arrest memo that the contraband articles have been seized from the truck, and therefore the petitioner is fully aware of the grounds for his arrest, and hence the mandatory requirement under Article 22(1) of the Constitution of India is met with, is complied with, right? Stop. Heard, perused, Abu Didiba. The primary ground urged in this bail application is as regard non-compliance of the constitutional and fundamental right of the petitioner guaranteed under Article 21 and 22(1) of the Constitution of India, apt to refer to Article 21 and 22(1) of the Constitution of India, which reads as hereunder, quote unquote 21, 22. Perusal of perusal of the aforesaid provision, it is apparent that the arrestee has a constitutional and fundamental right under the Constitution of India to be informed about the grounds of his arrest at the time of his arrest. Stop. The aforesaid mandatory requirement under the Constitution of India is not an empty formality. The Constitution guarantees the arrestee the right to be informed about the reason for his arrest/detention, and such constitutional obligation imperative upon the arresting authority cannot be easily brushed aside. Every arresting authority is obliged under the Constitution of India to mandatorily follow the procedure embodied under the Constitution of India while arresting an accused. Any non-compliance of the same cannot be tolerated by the Constitutional Court. Keeping the aforesaid principles in mind, let me now turn to the arrest memo in the case in hand to ascertain whether the petitioner was duly informed of the grounds of his arrest by the arresting authority while he was arrested. Stop. Page 23, Pava. The seizure and arrest memo reads, the seizure and arrest memo, what is the date?
My lord, 11/6/23.
11/6/2023 reads as hereunder, quote unquote. Eto gutetu koi diba. Reading of the aforesaid, it indicates that except noting the seizure made and the arrest of the joint possessor of such contraband articles, including the petitioner, nothing else so as to constitute the basic facts constituting the ground of arrest is mentioned. That apart, no other materials has been produced before this court by the learned APP to indicate that the petitioner has been informed of the grounds of arrest.
Your Lordship, if I may, here in the arrest memo, in the seized article, it is written how much they have
That
seized.
I have seen. That is already quoted. That apart, there is nothing else.
Yes, it has written that 5.
Ms. Vani, please don't disturb when the dictation is going on. Opposite that, when a ground for non-compliance of the constitutional obligation under Article 22(1) of the Constitution of India is urged, the burden lies on the prosecution to show that the petitioner stroke accused stroke arrestee has been duly informed of the grounds of arrest. Stop. In the instant case, the prosecution has miserably failed to show that the grounds of arrest has been informed to the petitioner as mandated under Article 22(1) of the Constitution of India. That being so, Article 22(1) of the Constitution of India has been totally violated. The apex court in Vihan Kumar Supra has clearly held that when a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused and statutory restrictions do not affect the power of the court to grant bail in such a situation. Paragraph 21 of the aforesaid judgment of the apex court reads as hereunder, quote unquote, para 21. In the present case, it is clearly discernible from the materials placed before this court that the accused petitioner was not informed of the grounds of his arrest. Stop. no documents whatsoever are available on record to indicate that the grounds of arrest as contemplated under Article 22(1) of the Constitution of India have been informed to the accused petitioner. Stop. Moreover, the case record does not indicate any contemporaneous record indicating that the ground of arrest was told / informed to the accused petitioner at the time of his arrest. Hence, I have no hesitation in holding that the arrest of the accused petitioner is totally illegal and invalid on account of failure to inform the grounds of arrest to the accused petitioner as mandated by Article 22(1) of the Constitution of India. Stop. Next para. It would also be worthwhile to mention that it also cannot be denied that the accused petitioner has been behind the bar for more than 2 years, 1 month, 4 days from the date of his arrest. Until now, the prosecution has been able to examine only 4 witnesses out of 14 numbers of listed witnesses. And it also cannot be denied that the prosecution may take a considerable period for completion of the trial. The listed witnesses, anybody has implicated the petitioner till now?
No, my lord.
The ones that is examined?
In fact, my lord, they have said that the driver, he was dropped at one point of time.
That apart, none of the listed witnesses who have been examined till date have implicated the accused petitioner. Start off part. In fact, one of them, okay, noko bayre kore digdar hobo. Apt to refer to the decision of the apex court in the case of Ravi Prakash Supra, wherein the apex court has clearly held that the prolonged incarceration generally mitigates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b)(2) of the NDPS Act. Paragraph 4 of the aforesaid judgment reads as hereunder, quote unquote, para 4. In view of the aforesaid foregoing discussion, non-compliance of there being clear violation of Article 21 and 22(1) of the Constitution of India being clearly established, comma, the rigor of Section 37 of the NDPS Act 1985 shall not affect the power of this court to grant bail to the accused petitioner. Stop. Hence, I shall be failing in my duty if the accused petitioner is not released forthwith. Therefore, further detention of the accused petitioner on this in the custody is totally unjustified. Accordingly, the accused petitioner, namely so and so, shall be released on bail in connection with the aforementioned case on furnishing bail bond of rupees.
My lord, may I pray for a small concession here? So this person was a truck driver. He's behind bars for 2 years, and his wife is a housemaid. Therefore, my lord, I pray that the amount may be considered accordingly. They are poor.
25,000, 30,000?
Yes, Your Lordship, I am praying for 50,000.
My lord, that would be too much for them to bear.
Since he is aware that he is the driver of that truck.
30,000. 30,000 only with 2 sureties of like amount, provided that one surety has to be a government servant, to the satisfaction of the learned additional session judge FTC number 3 Kamrup M at Guwahati, subject subject to the following conditions. Number 1, that the accused petitioner shall appear before the learned court of
Special judge,
so and so on
NDPS
each and
Act
every date to be fixed by the court. Number 2, shall etu bhalke frame kori diba, shall not directly indirectly je inducement threat hetu di diba. Number 3, shall submit his Aadhaar card, PAN card before the learned additional so and so, special judge so and so. Shall not leave the jurisdiction of the so and so without prior permission. Okay?
my lord, he belongs to Kachar district, Assam. So he has to.
Without prior permission. Okay? Granted.
So obliged, my lord. My lord, just a clarification. My lord has asked me a question regarding whether the PWs have implicated me. The only implication is limited to me being the driver of the vehicle, nothing further. So obliged, my lord, for accommodating a young counsel like me at 2 o'clock today.
It's all right, Mr. Barwa. Before this court, there is nothing like a young counsel or a senior counsel. All are equal.
I'm so
And,
obliged, my lord. I'm so
you've argued very nicely.
I'm so obliged, my lord. I'm grateful. The Vihan Kumar judgment, I gave.